David Shearer.
Chair. I just want to start by thanking the Minister for clarification on the question that Stuart Nash posed before, and notwithstanding the comments made by Jan Logie about the extent of this bill, I do agree with my colleague Claire Curran in terms of some of the issues that this bill actually raises and improves. It may not go as far as we would like it to go, and it may have been delayed, and I want to just start with a couple of introductory comments about that delay, because this piece of legislation, sir, has been in the mill really for about since 2006, when the Law Commission first put it out its first report. And it really has sat in abeyance on the order paper for, pretty much 5 years while it's been churning through. So it's a very long time. And to put that into just further context with just a brief comment, we have, sir, the 6th worst sexual violence record in the OECD. It's nothing to be proud of. We have an incredibly high domestic violence record. So the fact that it's taken this long to get through is actually pretty significant. This bill will not fix that record, but when you look at the fact that out of about 100 sexual violence cases, 10 of those get to court and 1 leads to a conviction, you can see, as the example that Stuart Nash was pointing out just a minute ago, that the fact that those odds are so long certainly does put off people from going forward and reporting those cases because of the stress and the duress they're going to be facing when they end up in court. But having said that, sir, I just want to point out a number of 3 or 4 of the issues that I think I'm particularly pleased to see in this piece of legislation. First, sir, is just in terms of children and the fact that a child witness, it is the onus has shifted to the point that child witnesses will give evidence in alternative ways. And alternative ways mean CCTV, through video, but not through direct personal presence inside of the court. This is significant in the sense that it is that it will mean that the presumption is that no child will appear in court, which is obviously going to be intimidating and traumatic for many of the child witnesses. So the fact that that has now become an assumption that would be the case. Now it's up to the judge. The judge can actually ask for the child, if the child would want to come into the court, but it would mean that cross-examination does not occur in an intimidating and potentially traumatic environment, and that, sir, I think is good. Certainly, secondly, the bill also provides that a child witness is entitled to have a support person when giving evidence, and may even have more than one support person if that indeed is necessary as well. And the provisions to support persons can apply whether a complainant or the witness is covered by those subsections, gives evidence in an alternative way or an ordinary way. So the support person will be there with the child, whether the child is giving evidence through a CCTV and video, or whether the child is actually physically present inside of the courtroom. Again, it's a small step, but a significant step forward in terms of being able to satisfy some of the issues that perhaps prevent people and particularly children from being able to give accurate evidence in a court of law. Sir, the other part, and there's been some other issues being brought forward, particularly about the video recording of evidence. There's a series of 3 offences under 95(1), which will enable if the video evidence that is being used is used inappropriately or shown publicly or whatever, there's a new series of offences that will come into play there. So, but the last thing I just want to mention, which is Section 95, which has been amended and replaced Section 95 with a defendant in a sexual case or a defendant in or a party to criminal or civil proceedings concerning domestic violence, Mr. Chair,
David Shearer.
Violence or harassment is not entitled to personally cross-examine. This is a significant issue because we have had in the past cases where the defendant has been able to stand up and to cross-examine and intimidate and in effect traumatise particularly a woman who was sitting, who was the complainant in the case, and put that person through an extraordinary ordeal in the court. The fact that that cannot happen now is, I think, significant progress, along with a number of the issues that obviously the Labor Party will be supporting. So, sir, I come back to the point where I started from. This has taken a long time to come through. It is a very significant piece of legislation in terms of enabling people to feel much more confident about taking their cases to court, gives a much greater chance of a conviction occurring as a result of that occurring. It may also provide or prompt some degree of the fact that people who might commit these crimes might deter them from carrying out those crimes because they know that they have a greater chance of being convicted in court, and may actually have a dampening effect on the committing of those crimes, because they are highly prevalent in New Zealand, much to our shame. So, sir, with those comments, I'll resume a seat. Thank you.
Tim McIndoe.
Move that the question be now put.
I'll call Louise Wall.